Court next calls State of Michigan versus Marvin Lee Niles Jr. This is case number 2511880I. We are here for a formal hearing on a speeding ticket of 35 and a 25. Mr. Sharkey, is there any resolution in this matter?
No, this time, Your Honor.
All right. Are we prepared to do a hearing then?
We are, Your Honor.
And Mr. Niles, is it still your desire to have the hearing today?
Yes.
All right. It's going to be a little tricky with you by Zoom, but we'll do the best that we can. Are you able to see and hear the court?
Yes, I can.
All right. Then Mr. Sharkey, your first witness.
Thank you, Your Honor. We will call Officer Ryan Brust.
Officer, if you'd like to come up to the front here, and I'll swear you in. I want to make sure that everybody's speaking loud enough so the microphones can pick everybody up. So please raise your right hand. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
You may have a seat. Mr. Sharkey, whenever you're ready.
Thank you, Your Honor. Could you tell me your name and occupation, please?
Officer Brust, Ryan, RYANBRUST.
Thank you. And what is your occupation?
I'm a police officer for the Cadillac Police Department.
Were you on duty on the date of April 4th, 2025?
I was.
Oh, hold on. We're having some issues with the recording system.
You may have to restart it. No, hit check and email. Okay, there you go.
I don't.
Good.
I don't have a judgment for this
Oh, let me print one.
one. Do we need to start over
Yeah, if we could,
from the very beginning?
very beginning.
All right. Okay, court recalls the State of Michigan versus Marvin Lee Niles Jr., case number 2511880I. Mr. Niles joins us by Zoom. We currently have Officer Brust on the stand, but we're going to have to restart because the recording equipment did not record. So I'll start at the beginning. It's my understanding we do not have a resolution in this matter. Is that correct?
That's correct, Your Honor.
And Mr. Niles, again, I'll ask you the same question. Is it your desire to continue with the formal hearing today?
Yes, sir, please.
All right. Now, even though the recording system was down, were you able to hear us up until that point?
I can hear clearly.
All right. Were you able to hear the witnesses and the attorney?
Yes, sir.
All right. Officer Brust, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Mr. Sharkey, if you could begin again.
Good morning. What is your name and occupation?
Ryan Brust, and I am an officer for the City of Cadillac Police Department.
Thank you. Could you spell your name for the record?
Ryan, RYAN, Brust, BRUST.
Thank you. Were you on duty on the date of April 4th, 2025?
I was.
What were you doing on patrol on that, or on duty on that day?
I was patrolling.
What were you patrolling for?
Speeders.
Were you using radar, LiDAR, some form of laser to check for speeders?
Radar.
Radar? Are you a certified radar operator in the state of Michigan?
I am.
The radar unit that you were using on that day, was that checked at the beginning and the end of your shift?
It was.
How was it checked?
So it has a test function. So we tested it and got the audible and the readings.
And were the readings satisfactory to pass the test?
Yes.
Thank you. Were you stationary or were you traveling on your patrol?
I was stationary.
Where were you stationed?
I was stationed on a like park and ride section on North Boulevard, just near 115.
And what is the posted speed limit there?
On North Boulevard, it's 25.
And on that day, did you observe anybody driving above that speed limit?
Yes.
Can you describe, was it more than one vehicle or just one?
It was just one vehicle.
Can you describe that vehicle for me?
It was a motorcycle with one occupant on it, and they were traveling faster than close to the speed limit.
And how did you determine that they were traveling faster than the posted speed limit?
My radar.
Now, what was that radar in moving mode, stationary mode,
Stationary.
stationary? Was there any form of interference or any prior false readings of that day?
No.
Was the target vehicle driving alone or was it going with the flow of traffic?
It was alone.
And what speed did you observe that vehicle traveling?
35.
35. And about how far away were you when you observed that vehicle?
I can't say.
Now, did you make contact with the driver of that vehicle?
I did.
Do you see that driver in the courtroom today?
Yes, he's on Zoom.
May the record reflect that the officer has identified the defendant?
It shall so reflect.
I have no further questions.
Mr. Niles, do you have any questions for this witness?
Yes, sir, I do.
Okay. You may ask them.
Okay, I just wanted to know, how far was it, when you first saw me, south of downtown near the freeway? How far did you follow me for? Do you recall?
I do not recall.
Okay. Do you recall driving from south of downtown where the exit to the freeway, I think it's 131. I'm not familiar with the area, but there's a freeway and a Shell gas station over on the east side of the city. Do you recall following me through downtown?
I do not recall.
You don't recall following through downtown, driving and then taking a side shortcut south of downtown and then zigging, zagging into North Street. Do you recall that?
No, I was not nowhere there.
Oh, did you say you were nowhere near there?
I do not recall that I was there.
Okay. Okay, I have no more questions for now.
Mr. Sharkey?
Thank you, Your Honor. People believe that Officer Brust's testimony.
No. Do you have any additional questions?
No additional questions, Your Honor. I apologize, Your Honor. I do have a couple further
Sure.
questions. Officer Brust, after you observed the vehicle traveling at 35 miles per hour, what did you do next? Did you initiate a stop?
I did. So I pulled out of my spot that I was stationed and I followed the vehicle. We came up to a stop on North Boulevard up to 115. He pulled off to 115 and I followed behind and initiated a traffic stop.
Do you recall about how far it was that you followed him before initiating the stop?
Not long at all. I would say approximately 2 minutes.
When you initiated the stop, how did you go about that?
Just like I typically, I ask for a driver's license, proof of insurance, and vehicle registration. And then as soon as I get provided that stuff, then I let the driver know why I'm stopping them.
And when you initiated the stop, did you initiate your stoplights?
Yes,
How long did it take for the defendant to stop after you initiated those lights?
not long.
I have no further questions at this time.
Mr. Niles, do you have any questions for the witness based on those questions that Mr. Sharkey just asked?
Yes.
Okay.
Okay. Prior to being on North Street, I did observe you following me for several miles, and you said you don't recall that. Do you recall me turning onto the main street through downtown?
Do not recall.
Can you speak up on that?
Okay.
I do not recall.
Do you recall me going 26 on North Street until we went down toward is it 115 on the highway headed toward Traverse City, near the high school through there?
No, I do not recall.
Okay. All right. Why did you pull off into the there's a park near the lake around the bend of the around the bend past the high school. There's a bend, and then before you get to the 115, if it's 115, I'm not mistaken, headed toward Traverse City. Do you recall pulling into the park and sitting stopped with your car off or the lights off beside the lake near in a park area after following me?
Yes.
Do you recall that?
Not following me, but
No, you follow. You follow. You don't recall after following me, you pulled into a park area near the lake.
that's where I was stationary, running radar.
You followed me for several miles before then. Followed me from south of downtown.
Mr. Niles, you're making statements. Do you have questions?
Oh, I'm sorry. Yeah. Yes. Do you recall parking in the You said you're stationed there. Okay. Um. Do you recall me turning off and taking the wrong road because I was by myself with my sleeping bag and tent, obviously traveling through town, and I wasn't in an extreme rush. So I mean, I wasn't going like 100 miles an hour by Cadillac High School, where I'm sure a lot of kids.
Mr. Niles, do you have a question for the officer?
Do you recall me taking a wrong turn into off of North Street into there's a straightaway where it turns, but it turns into a neighborhood which dead ends. Do you recall that before you turned into the lake?
No,
You don't recall it. Why didn't you pull me over before then?
I don't recall even.
Okay, no further questions.
Mr. Sharkey?
Yes, Your Honor. Officer Russ, before pulling the defendant over and observing him traveling above the posted speed limit, how long have you been stationary?
10 minutes. That's a lot. I'm not sure.
Thank you, Your Honor. That's my only question.
Thank you. Mr. Niles, do you have any questions based on that one single question that Mr. Sharkey asked the officer?
I have one more question. Do you not recall following me through downtown and then not going? I was going below the speed limit all through the Central Main route off the freeway, and then after you turned off, I was going under the speed limit. I may have gone down a hill or two to 115.
Mr. Niles, I need a question. I don't need a statement.
No further questions, sir.
All right. Officer, I have a couple questions for you. What time of day or night did this happen?
It was night. I would say early in the morning. I can't recall on the time.
Was it dark or light out?
It was dark.
All right, and this happened back on April 4th?
Yes.
All right. And you said by a park and ride, I think I know what you're talking about, but can you give me some more information as to where you were located?
So just past Rose Street, around the curve, the canal.
Yep.
There's a parking area there for fishermen to go into the canal or the beach.
Is it that parking lot that's right on the curve where the canal meets Lake Cadillac?
Yes.
All right. Where were you? And is that where you were located when you got the speed read?
Yes.
Which direction was the defendant heading?
He was heading, I believe it's what he's southeast. So he'd come around the curve and then he was directly towards me in my radar. And then that's when I got my reading. And then he passed and I followed.
Southeast. He was coming from 115?
No, he was not coming from,
Oh, hold on.
he was coming from, I would say, like the city of Cadillac.
So he's headed towards 115.
Yes, he's heading towards 150.
All right. Mr. Niles, what was your objection?
I was heading west.
Okay. All right. Which direction was your patrol vehicle facing as you were doing your radar checking?
It was, I would say, towards the north. It would be, I don't know the precise.
So let me ask it differently. Were you pointed towards the wood line, towards town, or towards 115?
I was pointed towards the wood line.
Okay. And that's a 2-lane road through there.
It is.
Mr. Sharkey, does that raise any additional questions?
Does not, Your Honor.
Mr. Niles, based on my questions to the officer, does that raise any additional questions?
Yes.
Okay.
I was headed. Do you believe I was headed west? You said it was southeast or west?
You corrected that to be to the west.
Okay.
He corrected it to be towards 115. So the court will
Okay.
take judicial notice that was west of his location.
I have no more questions.
Argument, okay, I'm sorry. Mr. Sharkey, may this witness be excused?
He may, Your Honor.
All right, you may step down.
Thank you, sir.
Mr. Sharkey, do you have any additional proofs?
I do not, Your Honor.
Mr. Niles, do you have any testimony or evidence or proofs that you would like to give on your behalf?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, what is it would you like me to know?
I'd just like the court to hear that it was about 3 a.m, if I'm not mistaken, and I was headed from my house in Flint to a function in Traverse City, and on my new scooter, and I drove from, I think it was Claire, cutting across into Cadillac. I think it was 115. I think it's still the 115, and I usually go a different route, which is strange, but I was like, I want to check it out. So I drove from Claire to Cadillac. I get to Cadillac. I had to stop. I was on the freeway, the expressway briefly, from 115 to the next exit north. I think there's a Shell station off the freeway pretty close to the expressway. I stopped to get gas there at 3 a.m. There were some very strange people loitering in that gas station. And then the clerk asked me, 3 a.m. at the Shell station, he asked me if I wanted a receipt. And he said something in a really weird manner. I was like, I could already tell something was going to happen this night. I could just tell it. So I filled up. I left the gas station. I was not speeding through town. I'm not sure which road it was. I get to the main street downtown, the main road north and south downtown. I looked on my maps and I was trying to head to 115 west of the city to get to Traverse City. I looked on my maps. It showed North Street cut across. I'm from Flint. It's been a while since I've been here. Being from Flint and driving from Flint to long trip. 3 a.m. by myself. Obviously, I had a sleeping bag, a camp roll on the back of my motorcycle, my scooter. I wasn't speeding excessively anywhere that I recall at all. I believe that he picked me, and I do know I saw him from south of downtown Cadillac. I saw him. I saw the cop, the police officer following me around. He wasn't exactly following me, but I could tell he was following me in a way. He followed me from south of downtown. He cut across a street or two south of North Street. He cut across, took a left. I couldn't have been. I had my cruise control on my bike. I know this guy. I had my set cruise control at 34. Going through downtown at 310 is nobody there by myself. He's the only other traffic cop. He cut across a street or two south of North Street and then zigzagged on 2 side streets and then intercepted me and came straight behind me on North Street. As if I was some kind of like criminal before he even knew what was going on. Just seeing somebody by themselves at 3 a.m. It looks like they're traveling around through town. And this being Cadillac, and I know we've had issues with people traveling through city. At night, I've heard stories. I talked to some students at the Cadillac High School. I've spoken with them.
That's not relevant. Well, let's get back on
Okay, I'm sorry.
your.
I'm sorry. I'm not an attorney, so I'm trying to do my best. I drove through. I wasn't speeding. I had my cruise control set at 34. I believe that he radared me south of downtown at 34, 35, whatever it says it was. And then when he got to North Street, I saw him following me. He followed me for probably a mile down North Street. And he didn't pull me over, which I was strange. I knew he was going to pull me over before I even got to high school, and before I got to Cadillac High School, I knew he was going to pull me over. There's a street that goes straight into a neighborhood, but it dead ends. I didn't know my way around. I veered off toward it, kind of intentionally, because I was wondering if he was going to follow me further. And I was not speeding through here. I had my cruise control set at, I think, maybe 26. He goes downhill, turns into the neighborhood. I stop, get to the end of the road. I see that it's not going to actually go through to 115. I turned around. He keeps driving over. He didn't pull me over at this point. So he turns into the park. If I was doing anything wrong, and I suspect he pinged the radar south of here, and then I think as soon as I got to the park where the bend is near 115, I think he just pulled up, and as soon as he saw me, without thinking, he came up and flashed his lights. I pulled over. I was upset about it because I could tell I don't believe him for 1 second. I never will at this point. I don't have a problem with it. I mean, I didn't want to be extremely rude. I was probably really tired too, so I wasn't exactly pleasant. I wasn't completely rude though. It's just the fact that I think I recognized what was going on here, and I tried to call him out. I didn't believe him, and he pulled me over after sitting there. He could have pulled me over early if I was doing something by myself. So I don't believe his story, and I'm certain that I've spoken to other people at Cadillac High School, and they've verified this before. I think they've talked to him before. So that's all I have to say,
You
sir.
you can't tell me what anybody else has said, so
I mean,
I have to disregard that.
no other witnesses, or
Yes, that's hearsay. You can't tell me what anybody else has said.
okay. I'm sorry. I don't. Well, he pulled me over. I thought if I was doing something, he could have pulled me over earlier. One of my list things to do. So, going through witnesses today. So I apologize. That's all I have to say.
Okay. Do you have any other witnesses or evidence that you would like to present today?
I had video, but I cannot locate it on my other phone because I usually have a GoPro on my bike, and I tried to locate it, but I cannot find it because I think it showed that I had cruise control set, and I believe that like I said, I believe he profiled me and radared me downtown or south of downtown or near the intersection of North where he turned onto it, and then I believe he sat there waiting for me to cross for no reason, and then just pulled me over. And that's all I have to say.
All right, thank you. Mr. Sharkey, do you have any questions for Mr. Niles?
No questions at this time, Your Honor.
All right. Mr. Niles, I have a couple of questions for you, and I want you to focus just on my questions, all right?
Okay.
So you had indicated that you had your cruise set at one point at 35. Where was that at?
South of downtown. As soon as I left the gas station, I left the gas station. There's a Shell station near the freeway. I set my cruise at 34. It fluctuated between 34 and 35. I never deviated from it. I'm not sure. I can't recall if the road turns onto the main north and south road through downtown, because Cadillac has a long downtown. I recall this. But as soon as I got into the main north-south route downtown, I left my cruise control on 34, 35. It never fluctuated. I got to North Street, and at this point, I already saw him snaking through downtown at this point. And I
Okay,
just
so what-
felt something wrong.
What happens when you get to North Street?
I'm sorry?
What happens when you get to North Street?
North Street, I was going before I saw him pick up from the corner. I was just driving through. I never like speeded or anything. I mean, I went down there were a couple turns or anything.
Did you have your cruise set then?
I did not have my cruise set because it was a hilly, windy road. So I mean, if I fluctuated slightly, it wasn't excessive, and it could have been more than 26 or 27 tops, because I did see at some point after I passed Cadillac High School, I did see the sign.
What street is a hilly road?
North Street's a very windy, turny road near a lake. And there's some hills in Cadillac too. And unless it's 3 a.m, I'm not familiar with the area.
Okay, so
May
I
I-
guess I want a clarification. Did you have your cruise on while you were on North Street or no?
No, sir, I did not. And but I did have my speeds. I was going about 25, 26, maybe 27 tops.
Now, you had testified earlier that you had your cruise set while you were on North Street.
No, I had my cruise control set through downtown and maybe into North Street, but I didn't have it while I was going through there. I did not have my cruise on because it was a windy road.
Okay. And I'm going to ask a crazy question because I'm not familiar with your bike or anything, but do you have to shift that bike or does it have an automatic transmission on it?
No, sir, it's an automatic transmission. It's a scooter. It's a 150cc scooter.
Okay, all right. Mr. Sharkey, does that raise any additional questions?
No, Your Honor.
Mr. Niles, you had no more evidence, am I correct? You said you had a video, but you don't have that with you to present to the court today. So
Yes, sir.
okay.
I'm sorry.
So, Mr. Sharkey, do you have any argument then?
Yes, Your Honor. People believe that Officer Brust's testimony shows by a preponderance of the evidence that the defendant was driving above the posted speed on North Boulevard at a rate of 35 in a 25-mile-per-hour zone. Officer Brust testified that he had been stationary there for approximately 10 minutes and via radar that had been properly calibrated that he is certified to use, observed the defendant driving 35 in a 25 on the morning of April 4th, 2025. Additionally, the defendant had testified also that he had his cruise control at one point set at 34 miles per hour. Then also had additionally testified that on North Boulevard, he had his cruise control set at 26 miles per hour, which he later corrected to say that he no longer had it on cruise control, which does raise some questions of legitimacy of that speed. So because of that, people believe that we've shown via preponderance of the evidence that the defendant was responsible for speeding in at a rate of 35 miles per hour in a 25-mile-per-hour zone.
Thank you. Mr. Niles, any argument?
Yes, I never said that. I said I had the cruise control on south through downtown. And once I got in North Street, I knew he was following me. So I turned off everything and just drove manually through town, through North Street. And I was not speeding through North Street. And he was not sitting there for 10 minutes. That's a complete lie. He followed me for several miles, at least a mile or two south of downtown. And does he have proof of the? Can I ask? Does he have proof of where the radar was taken?
The proofs are closed. So right now we're at argument. Is there anything else?
Yes, sir.
Okay. Based on the testimony that the court heard today, I do believe that the prosecution has met their burden in showing that the defendant was operating a motor vehicle in the city of Cadillac, in particular on what I believe starts as North Street, then crosses Lake Street, becomes Chestnut Street, then after a curve becomes North Boulevard. The officer testified that he was at the parking lot there at the end of the canal on what would be North Boulevard. Defendant admits to operating a motor vehicle on North Street, which the court, as I said, will take judicial notice that turns into North Boulevard. Defendant, I too heard the same statement that Mr. Sharkey did, that the defendant admitted to having his cruise control on at 26 or 27 mile an hour. And that is why I'd asked for the clarifying statements regarding the use of his cruise control. And while there was some testimony that through downtown, he may have been doing 34 to 35 based on his cruise, which in parts of downtown would have been speeding. I'm only focusing on the event at the location at North Boulevard. The officer testified that he had his patrol vehicle pointed, which would be in a northerly fashion towards the wood line, that North Boulevard through there is a 2-lane road. There were not any other vehicles on the roadway, that he is a certified radar operator, that the radar passed inspection, the self-check at the beginning and at the end, and that he was stationary. He also testified that the posted speed limit through there is 25 mile an hour, and that he had clocked the motorcycle doing 35 mile an hour. The fact that he may or may not have followed the defendant through town and to other locations is not relevant upon the court because it is based on this one incident of 35 mile an hour. It is not illegal for law enforcement to follow other vehicles through town. And I'm not saying that that's what happened, because the officer testified that he had no recollection of that and that he had been sitting radar at this location. I will also state that the city of Cadillac has more than one patrol officer. And so it could have possibly been another patrol officer that had followed the defendant. Nor does the defendant seem, not that it's his prerogative or responsibility to do that, but he certainly raised the issue, and there was no explanation as to how the officer who would have been following him actually got ahead of him and was in the parking lot. As such, I find, based on a preponderance of the evidence, that the defendant was speeding, doing 35 in a 25 mile an hour zone. So accordingly, that is the court's finding. There will be a fine of $70, costs of $10, state costs of $40 for a total of $120. Mr. Niles, are you able to pay that today?
I've actually already paid it.
You have?
It's an appeal, so we have it as bond.
Oh, I'm sorry. I didn't realize this was an appeal. I apologize for that. So yes, that has been paid already.
Yes.
So the court will apply that towards your fines and costs. Okay. Anything else before we adjourn? Mr. Niles, anything else?
Another level of appeal.
No, there's not an appeal beyond this point.
A state court or anything? Nothing. Okay.
Okay. All right. Thank you. We are adjourned.
I have Todd and Anderson next. We have 5 cases with Mr. Anderson this morning.
Hi, sir.
Mr. Anderson, good morning. Please, just a second, Mr. Anderson. Ms. Schuman, please.
Your Honor, I do have an offer on this case.
Okay.
Don't go to it. 1, 2, 3, 4, 5, 6.
Yeah, we have some suspended sentences, but go ahead.
So I'm showing 1, 2, 3, 4, 5, 6, 7, 8. I'm showing 8 cases.
I think we're talking about a different person. Mr. Anderson has 5 cases.
Oh, I apologize, Judge.
And I appreciate that you're going to tender on Robinson.
Yes. Okay. So for Anderson, he only has 1 new case.
Exactly. He has a bunch of suspended.
I apologize, Judge.
No problem. All right, Mr. Anderson, good morning.
Morning, sir.
Mr. Anderson, were you in the courtroom this morning when the video containing your rights was played?
Yeah, I know what. Well, I've seen it before.
All right. Do you understand your constitutional trial rights, sir?
Yeah.
All right. Did you have enough time to speak with your lawyer this morning, Mr. Loomis?
No, I haven't.
Yes. Mr. Loomis?
I did. That's what I did. I did.
Okay, great. Thank you. I'm just going to set the stage for us, okay? So just listen up and then we can go forward with the case. I'm going to let you know of your different cases that you have this morning, including the brand new one that brought you into custody. First, we're going to be on record in 24 CR 09916. In this case, Judge Champagne imposed 10 days in the Washoe County Jail on August 6th of last year but suspended that sentence for 1 year. Conditions: obey all laws and stay away from, can't read my own writing, Meadowood Mall, and let's see, Meadowood Mall and bus station, 4th Street area. I want you to understand that if you're found in violation of any new law, including this new crime you committed, you could be found in violation of that suspended sentence and have to serve that time. And that applies to all these suspended sentences. Do you understand that?
I didn't know that, sir. I didn't know.
Well, that's why I'm here. I'm telling you, I want to alert you to your rights and the possible consequences.
Oh, stay away. Stay
So
away.
do you understand that if you're convicted of any new crime, you could be in a violation of the Obey All Laws clause, and this suspended sentence and all the rest of them could be revoked? Do you understand that?
Yes, sir.
All right.
Thank you for that. Oh my God.
Let's go on to the next case, which is a community court case in 24 CR 10719. Allegedly, you failed to appear for a community court case review. Let me see if it's let me see exactly what that is. This is 719. I think it's failed to comply with a case management review.
I didn't even know about
Let's
it.
see what I did. Let's see what we got. You failed to appear for a case manager review on February 11th of this year. Do you wish to admit or deny that?
Suppose I admit it. I didn't know anything about it.
All right, I'll accept your admission and find you in contempt. We'll deal with that this morning. Then we're going to alert you to another suspended sentence case, and this is a big one. 24. Everyone, I have TC on this.
Judge, that was a transfer case from.
Thank you. Thank you. I appreciate that, from Sparks. And they sentenced you to 180 days in the Washoe County Jail. Suspended 2 years with 44 days consecutive. Oh, I'm sorry. With 44 days credit time served against that 180 days, and to run concurrent to another Reno Justice Court case. So I want you to know that if found in violation of that suspended sentence, that judge could theoretically revoke that suspended sentence, the remainder of it, and put you in jail for that time. Do you understand that?
Yes, I do.
The other suspended sentence I have in 24 CR 16038, I'm going to find that to be expired, case closed.
Hey,
And then
sir.
finally, your brand new case you have, Mr. Anderson. Okay, let's go through it. Your brand new case you have is in 25 CR 09196. You were charged with trespassing at the bus station.
Yeah.
This was alleged to have occurred on July 2nd, yesterday. Do you understand that charge?
Yes, I do.
How do you wish to plead to that charge?
Well, I own the bus station, sir.
You own the bus station?
Yeah, I do.
I will let everyone know there has been a competency evaluation that was rendered in the past, finding Mr. Anderson to be found competent to proceed. Mr. Loomis, have you had any difficulty communicating with Mr. Anderson? He's made a statement that, of course, raises some concerns to the court.
Judge, what I would say, Judge, is he made similar statements, but he seems to understand what's going on. And when I question him about some of the variety of the where he is, what's going on, and date, he responded appropriately to all those questions.
Okay.
He did make some statements that I think were fairly odd.
Yeah, that's an odd statement.
I'll do the bus.
Mr. Anderson, do you tell me, do you really believe you own the bus station, or are you just saying that out of hand?
No, I don't. No, I don't.
All right, thank you, because that's going to lead us in a different direction.
Yeah,
I'll
right.
tell you right now.
I don't.
All right, do you understand the charge of trespassing that's alleged?
Yes.
All right. How do you wish to plead to that charge, sir?
No contest?
Do you understand that by pleading no contest, you'll be waiving your trial rights on that matter?
Yes, sir.
Do you understand that means there will be no trial in this case, and instead we'll proceed to sentencing this morning?
Okay.
Is anyone forcing you to enter that plea?
No, sir.
Has anyone promised you anything in exchange for entering your plea?
No, sir.
I will accept your plea of no contest and find you guilty of that trespassing charge. Ms. Schuman, for the city?
Your Honor, I'm asking that you give him time served on the new case. However, I am asking that you impose the 10 days suspended in 24 CR 9916. One of the conditions was stay away from the bus station, and we are again with the bus station. I'll just defer to the court on the TC matter. With that being, another court's, order, I'll just submit on that. And
Thank you.
then I believe that's all. Thanks.
All right, thank you. Mr. Loomis?
Judge, Mr. Anderson is very concerned about the possibility of those suspended sentences being revoked. I think that the recommendation from the city to revoke just the 10-day suspended sentence because of the return to the bus station is, I concur with that recommendation. Mr. Anderson is on SSDI, so he has some resource, and it indicates that he would like to return to community court to
Good.
try to take advantage of that program.
The
And
library,
I'd ask the court to consider that.
at the library, I would love it, sir, for a year.
Yeah, Mr. Anderson, I think that's what you need because these
Yes.
cases are the same types of cases that we would address at community court. Because if we can address the underlying issues, you won't be committing these crimes. You won't be going, there will be no need to go to the bus station and cause an issue.
Exactly. Oh, God, I'd love to go there.
All right.
I'll put weight on.
All right, let's see what we can do here, okay? And you've got to know, this is really important. You have to know that Reno Justice Court really did hang a lot of jail time over your head. You have 180 days minus 44 that is just out there waiting to be revoked if you keep on committing crimes. And if you do, and it's my case now, it's
Okay.
transferred to me. So I get it, and I can make the decision whether I revoke that time and just have you sit it out in jail versus working on stuff, because one of the conditions of that suspended sentence is comply with the community court or cap court, whichever one, and you're in community court. So you've got to comply or you do that jail time.
Guarantee it.
And that's not the best strategy. I got to tell you, you sitting in jail is not going to help you or anyone else.
No, it's not.
All right, let's do this.
Oh, man, I love you.
Time served in 25 CR 09196. Consecutive to that time served, because I want you in custody until you're transported to community court next week. Consecutive to that time served, I'm going to revoke the 10 days Washoe County Jail. I'm going to waive all conditions of that case, and that case will be now closed. Let's keep the community court case open in 24 CR 10719. We can work with that case. And I'm not going to take any action in the transfer case 24 TC 15921 because you're still going to be under that suspended sentence and you're going to work with community court. I want you transported to community court next Wednesday, July 9th, I believe, July 9th. And we will continue our work with you because I want to work with you. I want to see if we can do something that affects your life in a positive way so that you don't commit these crimes anymore, okay? Thank you,
Yeah.
Mr. Anderson. We'll see you then.
Thank you very much, Your Honor.
Thank you.
I'm looking forward to this. Oh, man.
Michaela Magliochetti. Good morning.
Good morning,
Is it Magliochetti or Magliochetti?
Michael
Magliochetti.
Mm-hmm.
All right. Did you watch the video this morning that contains your constitutional trial rights?
No.
No?
Mm.
Deputy, was she in court this morning or did she arrive late?
She was here, Your Honor.
No, but I didn't see the video. I arrived late.
She might have entered right at the end.
Okay. Let me take you through your rights. This is important because you are facing 3 counts of simple battery on 2 different cases. And everyone who didn't watch the video this morning, listen up so that you understand the rights. You've been charged with misdemeanor crimes. As such, you need to understand that the maximum possible penalty on each misdemeanor crime is up to 6 months in jail and up to $1,000 fine. Do you understand those maximum penalties?
Yes.
You're entitled to enter a plea of not guilty to all of these charges and set the matters for a speedy and public trial. That would be set within 60 days of today's arraignment date. Do you understand that right?
Kind of. So what do you mean? So if I pleaded no contest, I want to get sentenced today?
Well, that's exactly right. But if you plead not guilty, you can set the matter for a speedy and public trial. Do you understand that?
Yes.
At that trial, if you chose to go to trial, you would be entitled to be represented by an attorney. And if you could not afford an attorney, I would appoint an attorney to represent you at no cost. Do you understand that right?
Yes.
You would have the right to have the city prosecutor prove each element of all of these charges beyond a reasonable doubt. That is the highest burden in the law. And if they were unable to meet that burden at that trial, you would be acquitted of the charge or charges. Do you understand that?
Yes.
Also at that trial, you'd be entitled to question the city's witnesses. That's your Sixth Amendment right. You would be entitled to call your own witnesses and use the subpoena power of this court to compel their appearance and have them testify on your behalf, and your attorney would be able to help you with that. And finally, you would enjoy the right to remain silent at that trial. You could not be forced to testify. And if you chose to remain silent, neither I nor any other judge would be able to take any inference from that or hold that against you in any way. Do you understand those additional constitutional trial rights?
Yes.
Great, thank you. Now, if you do plead no contest to any of these matters this morning, you would be waiving those rights. Do you understand that?
Yes.
You'd be giving them up. Okay. All right. Let's take you through your cases. Did you have enough time to speak with your lawyer this morning, Mr. Loomis?
Yeah.
Great. Let's go through it. And if you need more time, you say, Judge, I need more time to speak with my lawyer. We're going to be on record first in your older case. This is 25 CR 08534. And in this case, you were charged with a crime of simple battery. This alleged to have occurred on June 8th of this year at the Atlantis Casino. Do you understand that charge?
Yes.
Let me take you through your other case, and then we'll get going to see what you want to do. In your other case, which is 25 CR 09255, you were charged with 2 counts of simple battery. This alleged to have occurred yesterday, July 2nd of this year. And this in the area of the Best Buy, 5575 South Virginia Street. Do you understand those 2 charges?
Yes.
Mr. Loomis, is there going to be a not guilty plea to all of these set them for trial?
My understanding from my conversation is she prepared to enter a no contest plea in 08534, but a not guilty plea in
I
09255.
changed my mind though. I would like to plead no contest for both.
Okay. Okay.
I do
I
actually,
did.
Ms. Schuman then?
just to make it fair, if she pleads to 1 simple battery count in the 9255 matter, I'll dismiss the second battery charge, and then in addition pleads guilty to the battery in the 8534 matter.
All right. That sounds good.
Okay.
All right. Or do you want to accept that offer, Ms. Magliochetti?
Yes, I'll accept the offer. I just had a question if I could like take anger management classes.
That might be part of the sentencing. Now, I might not be the sentencing judge because I'll tell you what, sentencing, if you choose to enter a plea of no contest, will not be done this morning because there are victims involved. They're entitled to be at the sentencing hearing. It's a constitutional amendment that was passed recently. And so sentencing would actually be continued and we wouldn't hear your case until Monday morning. I want you to know that.
Okay, is there any possible way I could get OR'd?
No,
No. Okay,
I'm just letting you know, I'm being honest with you.
okay,
Okay.
all right.
So would you like to enter pleas today, or would you like
I
to?
would just accept the offer as it's accepted.
All right,
Contest, so let's get it with.
that's fine. How do you wish to plead to the simple battery alleged to have occurred on June 8th of this year at the Atlantis Casino?
Even though she was harassing me, so that's why I did it, I'll plead no contest.
Okay, well, that's a reason to plead no contest, right? You're saying, I don't admit anything and I'm not denying anything. I just understand that if it actually went to trial, the city would have enough evidence to prove it, and I don't want to contest the matter. That's what a no contest plea means, okay?
Okay,
You understand that by pleading no contest, though, you'll be waiving your trial rights I just went over with you?
that's fine. I don't want to be sitting in jail. I just want to go back home and find a
All right.
job.
All right. Anyone forcing you to enter this plea?
No,
Has anyone promised you anything in exchange for entering your plea?
no,
I'll accept your plea of no contest, find you guilty of that charge. And in 25 CR 09255, how do you wish to plead to count 1 simple battery alleged to have occurred yesterday?
no contest.
I'll accept your plea of no contest on that one as well, and I'll grant city's motion dismissing count 2 simple battery. And we'll gonna go ahead to sentencing. We're gonna continue these matters until Monday morning. Monday is they're gonna hold vids Monday morning, are they not?
Yes, Judge.
Okay, So we'll continue this matter until Monday morning, which is July 7th. Ms. Magliochetti will be placed on no bail hold in the 25 CR 09255.
No bail?
The other one is a citation.
Okay.
All right, we'll see you first thing Monday morning. We'll be sentenced, okay? Thank you.
Thank you.
Next matter I have is Michael Slabicki. Good morning, sir.
Yeah.
How are you doing this morning?
All right,
Good, 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 good. Thanks for joining us.
you're welcome.
Did you watch the video or hear me announce the constitutional trial rights you have?
I came in late, sir.
Did you just hear me announce those trial rights?
Yes, sir.
Do you understand the trial rights that you have?
Yes, Your Honor.
And do you understand the maximum penalties associated with misdemeanor crimes?
Yes, Your Honor.
Finally, did you have sufficient time to speak with Mr. Loomis, your lawyer?
No, Your Honor.
Mr. Loomis, can you remind Mr. Slabicki?
Mr. Slabicki, we talked about the trespasses, and we discussed the fact that you have some litigation going on and had a software company at one point. Do you recall that?
Yes.
That's your lawyer.
I'm sorry, I didn't,
That's
Right.
okay. That's why I'm clarifying, okay?
I just came back from the hospital, so I'm a little woozy.
All right. Do you think you're capable of handling these matters this morning, or maybe you're not in the best position to handle them and we can continue them to Monday morning?
No, I'm fine to handle them, sir.
All right, thank you.
You're welcome.
I'm gonna be on record first in 25 CR 02132. This is your suspended sentence case, and I'll tell you what it was. Judge Champagne in Department 3 ordered 15 days in the Washoe County Jail on February 18th of this year, but he suspended that sentence for 1 year. Conditions obey all laws and to run concurrent with all other RMC cases. I want you to know that if you're convicted of any new charge, including either of these new trespassing charges, you could be found in violation of that suspended sentence and have to serve that time. Do you understand that?
Yes, Your Honor.
Let's go to your next case then. We're going to be on record in 25 CR 09106. You were charged with trespassing. This at the Atlantis Casino, alleged to have occurred on June 27th of this year. Do you understand that charge?
Yes, Your Honor.
The other case we have is, same place. Let me see. Was there a return? Just 1 second, please. I want to see what happened. Is it Ms. Schuman? Do you know, was there a return to property? Is that it?
It's, at the Atlantis.
Gotcha. The other case is 25 CR 09235. You were charged again with trespassing, same date of June 27th at the Atlantis Casino. Do you understand that charge?
Yes, Your Honor.
Ms. Schuman, would you like to convey an offer, or do you want me to canvass Mr. Slibicki on both cases?
Yes, an offer of, if you please to the trespass in 9106, I'll dismiss the trespass in 9235.
All right. Mr. Slibicki, would you like to accept that offer?
Could you please explain?
Sure. Ms. Schuman, the prosecutor, has said that if you plead guilty or no contest to the trespassing in the first case I announced, 9106, she would dismiss the other trespassing in exchange for that plea.
No contest, sir.
Do you understand that by pleading no contest, you'll be waiving your constitutional trial rights then?
Yes, Your Honor.
You understand that means there will be no trial in this case and we'll proceed to sentencing.
Yes, Judge.
Anyone forcing you to enter this no contest plea?
No, sir.
Has anyone promised you anything in exchange for entering that no contest plea?
No, Judge.
I will accept your no contest plea, find you guilty of that charge, and I will grant city's motion dismissing 25 CR 09235. That's the other trespassing. Let's go to sentencing. Ms. Schuman?
Your Honor, I'm recommending credit for time served. I'm not asking for revocation of the suspended sentence of this week.
Thank you, Mr. Loomis.
Judge, I concur with that recommendation. It sounds like Mr. Slabicki used to have a software company with his wife. His wife died, and things have gone downhill since then. That software company, he's been unemployed for 6 years now. So it sounds like things have not gone well, but I concur with the recommendation from Ms. Schuman. I don't know if Mr. Slabicki has any interest in community court.
I think we've tried and it just kind of doesn't
work.
Doesn't
Okay.
have any footing there. So unfortunately, Mr. Slibicki, anything you wish to say before I sentence you? You're not required to say anything if you don't want to.
That's okay. You can sentence me, sir.
All right, thank you very much. I'm not going to take any action in the suspended sentence case. That's going to remain open until it expires on February 18th of next year. So just to remind you, you do still have 15 days hanging over your head until February 18th of next year, okay?
Sir.
On the new trespassing, credit for time served, but the other order is stay away from the Atlantis Casino, okay?
Yes, sir.
All right, thank you very much. Good luck to you.
Thank you very much, sir.
Thank you.
Yes, sir.
Chelsea Siracco. Ms. Siracco, good morning. Did you watch the video or hear me announce the constitutional trial rights this morning?
Yes, I did.
Did you understand the rights and the penalties associated with misdemeanor charges?
Yes, sir.
And did you have sufficient time to speak with your lawyer this morning?
Yes.
We're on record in 25 CR 09141. You were charged with trespassing. This alleged to have occurred on June 30th of this year at 1603 Wedekin Road. Do you understand that charge?
Yes.
How do you wish to plead?
No contest.
Do you understand that by pleading no contest, you'll be waiving the trial rights you heard?
Yes.
You understand that means there will be no trial in this case and we'll proceed to sentencing?
Yes.
I'll accept your plea and find you guilty of that charge. Ms. Schuman, how would you like to proceed?
Your Honor, we do have victims in this case. It's kind of a unique fact, so I'm requesting we have time for victim contact, preferably Monday morning.
Yeah, I saw that and I wondered if the city might be requesting that. It's a neighbor case where Miss Chelsea or Miss Siracco was making some loud noises. Let me review some more, please, before I hear from Mr. Loomis.
Your Honor, I'm happy to put it on the record too. It was more
Yeah,
than
please.
basically they live in a duplex. And it looks like the defendant can access the victim's sunroom through a door. And so when the parent was gone, she went through the son's door. I'm assuming it's a minor son, I'm not sure. The son was there alone in the room with two friends. And the defendant was saying something to the extent of she was looking for her son. So we might have some mental health issues here as well.
Agreed. Yeah, maybe. Mr. Loomis.
Judge, that's my understanding of what the facts were. She does not have an interest in going to community court.
Yeah.
She is currently unemployed, but not homeless.
Yeah. Let's go ahead and continue this for Monday morning. I do have concerns about the going into another person's residence. That does raise some red flags to the court, and there might be some mental health issues that need to be addressed. But nevertheless, that person has a right to be at sentencing, and I'm going to go ahead and allow that. And we're going to place Ms. Siracco on a no bail hold pending sentencing. Sentencing will be had on videos on Monday morning, July 7th. We'll see you then, Ms. Siracco. Thank you.
I was invited into their home.
Well, you can talk about that to the sentencing judge. Kevin Dusick. Good morning, Mr. Dusick.
Morning, Your Honor.
Mr. Dusick, were you in the courtroom when the video was played or when I announced the constitutional trial rights?
Yes, I was, Your Honor.
Did you understand the rights and the penalties associated with misdemeanor crimes?
I do, Your Honor.
And did you have sufficient time to speak with your lawyer, Mr. Loomis?
Yes, I did.
All right, thank you. We're going to be on record in 25 CR 09245. Just one second. While you were originally arrested for the crime of domestic battery first offense, the city has filed the crime charge of simple battery. This was alleged to have occurred on July 2nd of this year in the vicinity of 595 Booth Street. Do you understand that charge?
Yes, Your Honor.
How do you wish to plead to that charge, sir?
Not guilty, Your Honor.
I accept your plea of not guilty. I have reviewed this matter for probable cause, and I do find that probable cause exists to support Mr. Dusick's custody status and the charge of simple battery. Let's see here. I believe you qualify for counsel. Let me check that again, though. You do qualify for the appointment of counsel. Would you like me to appoint an attorney to represent you?
I would appreciate that, Your Honor.
That will be the order. Mr. Dusick will be represented by appointed counsel. Let's get a bench trial date, and then we'll go to custody status. Bench trial?
What's the possible?
Just a second.
August 12th at 1 p.m.
Your bench trial is set for August 12th at 1 o'clock in the afternoon. That'll be at the Reno Municipal Court. Now we're going to go to your custody status, which will probably answer your question. Ms. Schuman, the city, please.
Your Honor, $2,500 bondable bail is what I'm asking for. In this case, he battered his mother. She went to pick him up. He popped the hood, started looking in the hood, I guess. The victim was trying to get him back into the car. He grabbed her on her back with both hands. He was pulling her aggressively while she was trying to walk away. This was observed by 2 independent witnesses. One of the witnesses actually said that after she tried to walk away, he hit her a couple more times. He does have lengthy criminal history, including concerning arrests. June 2024, we have assault with a deadly weapon ×3. No dispo on that is listed. Drawing a deadly weapon in a threatening manner. That was dismissed. Allowing a child abuse, neglect, gross misdemeanor charge, no disposition, same from June of 2024. He's
These are all
also
charges that were dismissed.
destruction of property, pled guilty to in 2022. Another resisting a public officer, grand larceny charge, he pled guilty to in 2020. So based on that, Judge, I think we've met our burden here. He also scored a 12 on the MPRA. If he is released, I'm requesting a no contact order with victim Annette Dusek, D-U-S-E-K.
All right, thank you, Ms. Schuman. Mr. Loomis, what would you like to offer, please?
Judge, Mr. Dusek has been in Reno for, he's 35 years old. He's been in Reno for his entire life. He does have a place to stay away from Ms. Dusek. He can live with his brother in Sparks. He's got a variety of trades that he's followed in a number of years, which include culinary, carpentry, landscaping, a variety of contracting trades, and believes he can quickly find a job if released. I would ask the court to, and it is alleged that he grabbed Ms. Dusek by the back, and that she turned around and punched him in the face. And so I would ask the court to consider a $1,000 bondable bail.
Thank you, Mr. Loomis. Mr. Dusek, anything you wish to say with regard to your release, not about the facts of the case? You're not required to say anything if you don't wish to.
I appreciate what the Washington County Detention Facility offers. It is free room and board. I've been struggling on the streets, so I'll take the free meals and the free bed until we do a bench trial. I don't understand the proceedings of misdemeanors or anything like that. So with all due respect, I mean, I don't have money to bail out. I have money to get into a place of residence when I am released, when eventually I get back out to the community.
Right. No, that sounds good. City, I find, has met their burden under Valdez Jimenez, showing by clear and convincing evidence the need for bail, that non-monetary conditions themselves will not suffice in this case. That's in light of defendant's criminal history and in light of the 12 on the MPRA score. Bail will be set at $2,500. That'll be a bondable bail set. The conditions are as follows. You will obey all laws. You will neither consume nor possess any alcohol or drugs without a prescription. It's going to be basic supervision. There is no drugs or alcohol alleged in this particular case. Just 1 second. I may have misspoken. Strike that. If he does get out of custody or does secure his release, the testing will be enhanced supervision. I find that that's necessary under subsection 9 of the MPRA, that there's past history of substance use issues. So I am going to place Mr. Dusek on enhanced supervision in light of that. Final condition, you will have no contact with Annette Dusek. We'll see you on your trial date, sir. Thank you.
Sir. Over here.
Aaron Phillips.
Good morning.
Morning, Mr. Phillips.
Good morning.
Mr. Phillips, were you in the courtroom this morning when I announced the constitutional rights or when the video was played?
Yes.
Did you understand the rights and the penalties associated with misdemeanor crimes?
Yes.
And did you have sufficient time to speak with your lawyer this morning, Mr. Loomis?
Yes.
Great. We're going to be on record in 25 CR 09241. And in this case, you were charged with 2 counts of obstructing and resisting. Wrong case. My apologies. You were charged with 1 count of trespassing, 1 count of simple battery, and 1 count of resisting a public officer. These charges were alleged to have occurred yesterday, July 2nd, in the area of 10585 Stead Boulevard. Do you understand all of those charges?
Yes.
Mr. Loomis, are we going to enter not guilty pleas to all, or do you wish to consider an offer if there is one made?
My understanding is that Mr. Phillips wants to enter not guilty pleas.
Gotcha. Mr. Phillips, how do you wish to plead to the charges? Let's see, I don't know what's happening because I'm on single.
Sorry, I'm
Mr. Phillips, how do you wish to plead to the charges, please? Your attorney said you wish to enter not guilty pleas instead.
guilty, Your Honor.
I accept your pleas of not guilty. Let me see. I think we're missing some information, but I think I have it now. Let me look at your case real quick. I have reviewed the matter for probable cause, and I do find that probable cause exists supporting Mr. Phillips' custody status and all of the charges. I find that you qualify for the appointment of counsel. Would you like me to appoint an attorney to represent you on this matter?
Yes, Your Honor.
I will appoint counsel to represent Mr. Phillips. Let's get a bench trial date, and then we'll go over your custody status. Bench trial?
August 12th at 1 p.m.
Your bench trial is August 12th at 1 o'clock in the afternoon, and that'll be at the Reno Municipal Court. And like I said, you will have an attorney representing you on this case. Let's go to custody status. Ms. Schuman.
Probably $3,000 bondable bail in this case, just given the nature of the charges. In this case, he went into the Jackson's gas station. He had been trespassed several times that day. He came back in the last time he was arguing with 3 individuals who were at the slot machines. He actually had to be taken down, had to be pepper sprayed. He hit the victim in the back of the neck. Then when law enforcement arrived, he wouldn't sit still. He was completely uncooperative with the officers, refused to identify himself. He does score a 5 on the MPRA. He also has criminal history, including a felony controlled substance possession from 2007. There's no dispo on that. Let me see if I have something more recent. He's got firearms dangerous weapon violation from 2008, misdemeanor. Let me see here. Another controlled substances possession from 2009, no dispo. Looks like a lot of drug stuff. Hang on, yeah, that's all I'm saying is mostly drug stuff. He also scored a 5 on the MPRA. If he is released, I want a no contact order with Vincent Vanover. That's our victim, and that he stay away from Jackson's gas station, located at 10585 Stead Boulevard.
All right, thank you, Ms. Schuman. Mr. Loomis, what would you like to offer, please?
Judge, Mr. Phillips reports having been in Reno for 1 year. He's 39 years old. He reports that he's been working at Costco as a warehouse worker for 1 year and lives with his aunt here in Reno. He's got 2 kids. Looks like 13 and a 13-year-old daughter and a 7-year-old son, which he has a support obligation, which is largely current, but has some arrearages that he still has to address. And the kids are with their mother at this point. I would ask the court to consider, and I think the charges that have been reported by the city are pretty old. I would ask the court to consider a 1,000 bondable.
Okay. Thank you, Mr. Loomis. Mr. Phillips, anything you wish to say about your release from custody, not about the facts of the case, and you're not required to say anything if you don't wish to.
I'm sorry, can you repeat that, Your Honor?
Yeah, would you like to say anything about your release from custody and how that works? You're not required to say anything, but if you do speak to me, don't discuss the facts of the case, please. You're entitled to remain silent as to those facts.
No, Your Honor, I'm fine.
All right, I do find that the city has met their burden under Valdez Jimenez, showing by clear and convincing evidence the need for bail, that non-monetary conditions, I believe, will not suffice in this case. And that's in light of the facts in this case, and it's old criminal history, but it's criminal history. But that does support, I believe, Mr. Loomis, you're right, a lower bail set than the $3,000 bondable. I'm going to impose a $1,500 bondable bail. Cut it in half, essentially. The conditions of your release, should you make that release, Mr. Phillips, are as follows. Should you secure your release by posting that bond, the conditions will be that you obey all laws, that you will neither consume nor possess any alcohol or drugs, and that includes marijuana. You are to report on release to the Reno Municipal Court to sign up for enhanced supervision. I'm not sure about what happened, but there are at least indications in this case that there may have been drugs ingested or involved, and there are previous possession of controlled substances cases in your criminal history, and that supports a finding of the need for testing in this case. Finally, you will stay away from the Jackson's Market located at 10585 Stead Boulevard, and you are ordered to have no contact with a Vincent Vanover. That'll be your bail. Thank you, sir.
Thank you.
36 days jail credit. All right, Mr. Pelfrey, it's alleged that on or about May 18th in the city of Sturgis, you were at the Meyer store and you stole property worth less than $200. That's commonly known as retail fraud in the third degree. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You stole some liquor and put it in a backpack. And a little Debbie strawberry shortcake roll, $28.77. As I indicated, retail fraud is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Prosecutors recommending that if you plead guilty to the charge, I simply give you credit for jail time served, which is 36 days. Do you understand the charge? Do you understand the plea offer? You have to speak up. I can't.
Yes, I do.
All right. Do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, I do.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Keith Stickley, the chief public defender, is here, but we could also appoint a lawyer to represent you if it actually went to trial. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand all that?
Yes, I do.
All right. Were you in the Meyer store on May 18th and tried to steal some liquor and some strawberry shortcake roll?
Yes, yeah.
You were homeless back then. Are you still?
Yes.
You've been in jail since May 18th? That's not about right.
No, it's May 29th.
May 29th. All right. $28.77. I don't know how pink whiskey and strawberry shortcake goes together, but probably not very good. What are you gonna do when you get out?
Well, I'm not getting out for a while. I got money for another case, but
Oh, you got a hold from Judge Stutzman? All right. 36 days credit, 36 days. Minimum fine of $125 or 2 additional days, which will get swallowed up by the time you're barred from Myers. Let me see if I can take care of some of these other cases. Well, you got several retail frauds that you haven't paid on, and I'm gonna just wipe them out with jail time. Let me find them. Some might be ordinance. All right, let me look at some of these. There's a bunch in here. 231351.
yeah, I'm hoping to get the sun on my next case, and then I can my life back track.
All right. I'm gonna wipe out these other ones. You're on a payment plan. 231351 OM. Failed to pay fine and costs and a retail fraud. 36 days credit, 36 days. Concurrent with 25117 OSM. Wipe that fine and cost out. 19830 ON. Fail to pay fine and cost, 36 days, credit 36 days. 202074. So ordinance. Might as well wipe that one out too. 36 days, credit 36 days. Wipe out your fines and costs. So I took care of 3 unpaid retail frauds that you had a payment plan on that you weren't making any payments. So this resolves 4 of them. You got 36 days plus 2, but you're held on some other matters, so you're not going to get out anyway. But this took care of this most recent case involving a liquor from Myers. You're barred from Myers. or you're in contempt of court, and I wiped out 3 of your old fines with jail time served.
I got charged 11th possession methods.
I don't have any control over that one right now. 11th, that'll be next. That's in front of Judge Stutzman.
No, the 7th, I was going in front of Stutzman, and this one, I think they got a waiver, I guess.
All right, well, I took care of as much as I could here. You got a paraphernalia, a paraphernalia, attorney pretrial. Yeah, let's take care of that one too. Could I should have pulled that. Laura, could I have Mr. Pelfrey's pretrial case 241589, possession of paraphernalia under Sturgis ordinance? Might as well clear house and save you a trip, save them a trip. That is 241589. So let's take a look at that one.
Sounds that way. No, that's not. That's not paying.
In that case, Mr. Pelfrey, it's alleged, according to the ticket, that on August 26th of 24, this is old, that you did possess paraphernalia. 2 syringes and 2 baggies with crystal powder that you'd used to inject. You're here on another case, I said, in a pretrial. I don't think they actually appointed an attorney. No, they did. Mr. Gibson's your lawyer on that case. They just didn't deal with it at your other case. If you wish to plead to that paraphernalia charge, I'll take your plea, but you'd have to waive the presence of Mr. Gibson. I'm just going to give you 36 days and package in it with everything else. Are you willing to admit to that charge? That's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500 under Sturgis ordinance. You do have an attorney, but you can waive your right to an attorney to enter a plea if you wish to. Is that what you wish to do here?
Yes, sir.
We had a brief discussion just now about it too, Your Honor.
All right. Other than what was said here, did anybody promise you anything to get you to plead to this?
No, Your Honor.
You've been in jail for 36 days. You're turning back into Tim Pelfrey. You seem very clear-headed, clear-eyed today. I've seen you some days where it wasn't so good. I like this version better. On that day, did you have some syringes and some baggies?
Yes, Your Honor.
All right. Same amount of jail credit, 36 days. 75 and 50, $125 or 2 additional days concurrent with your other cases. So that took care of 2 current cases, the retail fraud of the liquor in May, this old paraphernalia charge from August of 24, and 3 old unpaid retail frauds. So I took care of 5 cases.
Thank you.
You still got other stuff to deal with, but those are 5 less you need to be concerned about. Forced clean time is valuable. It helps you start to think more clearly. The trick is to keep you on clean time after you get out. But we'll see where that goes. But this took care of 5 of your 10 cases or so, but
I've been talking to Pivotal, and if I didn't, my insurance wasn't canceled, I was gonna have it set up to where I could go to rehab as soon as I get out.
well, I think that's a good plan. I think that may be something, maybe they put you in drug treatment court and circuit court or something, but we'll see. I hope so. You're good to go, sir.
Courthouse case of the people versus Brooke Bailey.
Assistant Public Defender Jay Bellinger on behalf of Miss Bailey. Miss Bailey, can you please state your name for the record?
Brooke Bailey.
Your Honor,
She's waiving.
yes, she is.
Ma'am, you're waiving your right to a preliminary examination.
Say yes.
Yeah, yes,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
yes,
People also waive the right.
That's right.
Preliminary examination having been waived, defendant found over to circuit court on a single count.
We acknowledge receipt of information, wait formal reading, stand mute at this time, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
Perfect.
at 1:30 with Judge.
July 22nd, 2025, 1:30 for Judge Competency. Bond continued.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Quincy Jones.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Jones on case ending 0697.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones in case 21574.
Okay, in both cases, I have an indication that there are plea agreement form that he is going to be guilty to an added count 2 of use of a controlled substance in both matters, a 1-year offense upon a successful plea with those charges count 1 in each case.
That is correct, Your Honor.
That is correct, Your Honor. I have gone over his rights with him.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me God, yes.
State your name.
Quincy Jones.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 counts of use of a controlled substance.
Yes.
All right. Is that correct?
Yes, Your Honor.
Those are misdemeanors, punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
I understand.
You understand also in one of the cases, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance contained in case ending in 0697, how do you plead?
Guilty.
To that same charge contained in case ending in 0574, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights?
No, I read them thoroughly.
Pardon?
I read them thoroughly.
You understand them?
Yes, I do.
All right, so you have no questions.
No question.
Is anybody? I think we look at paragraph 5, excuse me. Copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, no, not necessarily on the record.
He's asking if everyone's made you any promises.
No.
Anybody threaten you or coerce you in any way?
No, they haven't.
You're doing this voluntarily
Yes, I am.
of your own free will,
Yes, I am.
and because you believe that you are indeed guilty of these offenses?
Yes, I am guilty of these offenses.
Okay. Starting with the case in the 1482 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I had.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, I did.
All right. Sir, I need you to also understand that if I accept your plea and between the time of sentencing and the time of, between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule and would it be proper to accept the defendant's plea?
He was satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count 1 is dismissed. In the 1482 matter, pre-sentence investigation and report is ordered at 1482 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address?
I knew it. I was trying to sneak it in before you said something, rushing. In the other matter, let me just finish up the other matter. In the other case, defendant is if I didn't say so. No, count 1 is dismissed, except the plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1481 probation. Sentencing will be
July 30th, 2025 at 12 p.m.
no. I have a sentencing. 9th, he's in custody. That's the date we'll give. July 9th, 2025. Time? 9 a.m. So you can come here and then get over to Judge Barr, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor, but Your Honor,
it wasn't just he didn't go to community corrections. Isn't that correct?
that was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Yeah, he probably came down off all those drugs. Go ahead.
Well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at his sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor, consider reducing this down to a personal bond.
Your Honor, I would just add that I have been in touch with the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and happy to fill in Ms. Rushing as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else may have been in his system. The concern for the people added to that is that prior to that, Eric's in court under the influence, Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of staying for using drugs. And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I will prefer that he at least remain in custody until his sentencing on July 9th.
All right. Until I have an additional evaluation, I'm going to deny the request for any type of bond reduction. Defendant bond will continue in each poll.
Thank you. Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Court calls the case, People versus Elton Bell. Oh, boy.
Good morning, Judge. Kerma Dadush on behalf of Mr. Bell, not with. Mr. Bell is 65 and is not able to drive. He had a ride who was supposed to bring him here. He told me he's
If
fine.
you say he's coming on a bus, I'm coming up.
He's not, I don't even think he can navigate a bus. Not because of, he's just,
I even tried to get him on Zoom. I don't think he can navigate that either. I would have gone down that route knowing he does not have a consistent ride. In any case, Your Honor, can we please pass on this?
You want me to pass it?
Yes, please. He said
Okay.
he's trying to find
And what's
another
gonna happen?
when he comes.
Between,
Oh, he's finding another ride. He's appeared every time before, Your Honor. I believe it's his first time not appearing. I can get him to send photos of a bus.
of what? You know what?
If that would
You know
be
what?
helpful.
I'll pass it.
Thank you, Your Honor. Thank you, Your Honor.
Wow. Court calls the case People versus Rahman Muhammad.
Andrew Childers of Grant on behalf of the people. Kyle Burdell on behalf of Mr. Muhammad. Mr. Muhammad, please state your name.
Rahman Muhammad.
And Your Honor, may we approach briefly? Very briefly.
Yes.
Thank you, Judge.
Our record should reflect that we had a bench conference in this case. They're requesting an adjournment.
Yes, Judge.
Probable cause conference, July 17, 2025, 9 a.m. Bond
Judge. All right, we'll be in touch, my friend, and we'll come to the judge.
Court calls case People versus April Black.
Your Honor, Alexis Plumey on behalf of Miss Black. And Miss Black, could you just state your full name? April Black. And Your Honor, today is the date and time for a probable cause conference. I do have a green sheet filled out. We are just asking for an adjournment for plea negotiation purposes, if we could go about 2 weeks. And then, Your Honor, I would like to address a couple conditions of bond.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Yes, that's the bond.
So currently, Miss Black is on a GPS tracking tether. And there is also an order that she not go to her mother's house, but not in order that she not speak to her mother. Miss Black lives about a block away from her mom. It's my understanding there was an incident immediately preceding this one that is still being investigated, where Miss Black and her mother would be the alleged victims. From what I understand, Miss Black was ordered not to go back to her mother's place because another person involved may live in the area. However, Miss Black has 4 children. She's still living a block away from her mother's house, and it is just inconvenient that she can't go over there and drop her kids off because her mom does help with childcare. And additionally, I feel that condition doesn't really relate to the charges in this case. So if you'd consider lifting that no-go to and removing her GPS tracking tether. And I don't believe there's any suggestion that Miss Black is a flight risk.
Response?
I would ask at least for this, at this point, the remain is currently set. When the police had contact with Miss Black, it wasn't a call regarding potential FA, but she was highly intoxicated, really aggressive with police, ended up doing construction. The police car was combative. I'm just concerned, whatever the heck is going on at that 407 address, I would hate for there to be any sort of bringing up whatever dispute led to the initial police contact that would cause Miss Black to have a negative impact on this case.
Motion for modification of bond, change in any conditions is denied. Bond will continue with its conditions.
Your Honor, if I could just clarify about the tether, I believe the tether is just tracking her. It's not an exclusion zone.
It's a location tracking tether.
Yes, so I'm not sure, what purpose that,
So you
It's-
want me to redo the ruling I just gave? Is that what you're asking? How many times have you been before me? Yeah,
Few.
how many times have I ever done that when I finally ruled?
Understood, Your Honor.
Never.
Understood.
So I don't know why you'd think I'd start today. So are we done?
Yep, we're done.
Okay, thank
you.
Court calls the case, People versus Raymond Bowman.
Constable Bass on behalf of Mr. Bowman, Your Honor. Mr. Bowman, can you state your full name for the record?
My name is Raymond William Bowman. I have before me a plea form. Is that what we're doing?
Yes, that's correct, Your Honor.
Plea form indicates that the defendant will plead count to possession of a weapon in a weapon-free school zone. Misdemeanor. And upon a successful plea to that charge, count one would be dismissed.
That's correct, Your Honor.
Is that a correct statement?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Raymond William Bowman. Sir, it is this court's understanding that you are pleading no contest to the charge of possession of a weapon in a free school zone, in a weapon-free school zone. Is that correct? Yes, Your Honor. You understand what a no contest plea is? Yes, sir. Two things about a no contest plea I have to make sure that you understand. The first thing about a no contest plea that you have to understand is that it means that you are not further desirous or wanting to contest this charge. You understand that? Yes, Your Honor. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Yes, Your Honor. Basis for the no contest plea.
You're under potential civil liability.
And understanding all of that, sir, you still wish to plead no contest? Yes, Your Honor. And to that charge, how do you plead? No contest, Your Honor. Now, you understand that by pleading no contest, you will not have a trial of any kind? Yes, Your Honor. You signed an advice of rights form, is that correct? Yes, Your Honor. Any question regarding any of those rights? No, Your Honor. Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form. I understand, Your Honor. You understand you're giving up your right to appeal outright? Yes, Your Honor. Are you on probation or parole? I am on probation in Wayne County. Were you on probation at the time of this offense? No, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? No, Your Honor. Has anybody threatened you or coerced you in any way? No, Your Honor. You're doing this voluntarily? Yes, Your Honor. And of your own free will? Yes, Your Honor. The court has been provided and has reviewed Michigan Department of State Police report for their case number 4613-20. Any objection to the court having reviewed that report?
No objections, Your Honor.
Counsel, there is not an indication of a school, the zone.
It would just be to the higher, you know.
So accepting the higher,
There's no good misdemeanor for a firearm.
so in looking at that, then, all right. Sir, if I do accept your plea, I have to have you understand that any sentence evaluation, if there were any or any recommendation, the court would not be bound by if you committed any misconduct as defined in the Michigan court rules. You understand that? Yes, Your Honor. You also understand that you not be entitled to withdraw your plea. Yes, I understand. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied, Your Honor.
And based upon the police report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. The court will accept the defendant's plea to No contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
July 9th, 2025.
July 9th, 2025, 9 a.m. That's before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, my client is asking to be released on a PR while he waits his sentencing. My client is unfortunately very ill. He needs to go back to the hospital. He's actually due to have a procedure done today at 3 p.m. It's quite an intense procedure. He's also going to be
Is the only thing holding him?
Here, yes.
What do you mean here? Yes.
He has a hold out of Wayne for the BMI. He has been warned 4 times in this case already. So people think he should be held until at least see by permission.
The bench warrant, I believe, was due to him being hospitalized, and that's why he failed to appear previously.
What about the bench warrants in?
To be released to treatment from Wayne County. That's why my sentencing would need to be. I'm going to the Salvation Army, and I need it set up on Zoom. So if you were to release me, I would go to Wayne County Jail and wait for treatment to pick me up, and then I would be at the Salvation Army there.
Anything else?
Nothing further, Your Honor.
I don't think it's appropriate given the defendant's track record in this case and the very fact that he has another hold to release this defendant. Therefore, the motion for bond reduction in this case at this time is denied. I'll be seeing him next week. So
understood, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls case of the people versus Jaleesa McDowell.
Your Honor, Amy Riser, Your Honor, Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Ms. McDowell.
Okay, permission to practice is great.
Thank you, Your Honor. Ms. Dr. Could you say your name for the court, please?
Jaleesa McDowell.
Thank you. All right.
Your Honor, we would like to request the court set a date for exam in this matter, please.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 15th?
Yes, July 15th.
Yeah, July 15th. Will that work?
Yes. And to address the issue.
Preliminary examination in person will be set July 15th, 2025. 9 a.m. That is before Judge Moore. As to bond.
Thank you. Your counsel has been provided with several of the defendant's jail calls. And we're asking that her calls be revoked at this time. She's actively trying to have third parties contact the minor child in this case to have her recant. So we're asking that her jail calls be revoked and if necessary, a date be set for a hearing.
Your Honor, I've listened to the calls myself, and while in some regards, Ms. McDowell does talk about her case to people, she very rarely makes requests. Her tone is not demanding or threatening or coercive.
Rarely makes requests?
Well, I mean, I'm talking about a request in general, Your Honor. So, but there are a lot of conversations, and for the most part, her tone is not demanding or threatening or coercive in any way. And mostly she's just talking and trying to communicate with her mother, her grandmother, and her cousin and other family members.
But are there indications that not only, because those would be third-party contacts, but is there an indication where in any reasonable fashion it could be read she's making a request for somebody to recant their story?
Your Honor, I believe that in most of the situations and most of the phone calls that we heard, she wasn't making requests. as much as just expressing how she was feeling about certain issues with her grandmother and her mother and the people who are taking care of her children right now.
It really doesn't answer my question, but
Yeah,
that's
right, but,
fine.
we did meet with Ms. McDowell yesterday. We talked about that. I will say Ms. McDowell was very candid. We went through some of the phone calls together. Her understanding, she had no intent to disobey the court's order. She's not in any way trying to intimidate or coerce anyone to come to court or to not come to court. Her position is that she has other children involved. She was getting messages that these children are left unattended at her home. She's very concerned about the safety for them. That has now been resolved. After my conversation with McDowell, she even said, I don't plan to be on the phone anymore. I was never trying to disobey the court's order. That was not my intent, but obviously she has concerns for the safety and well-being of other children that are they now are placed with someone that she knows, and she does not have that same concern for their safety and well-being at this time.
If I could, Your Honor, provide an offer of proof, just an excerpt from one of the calls.
Yes.
This is the defendant speaking on June 19th, 2025. She's got mental problems. She's got mental problems. Me and Melanie don't speak because she done put $300 worth of damage in her house. I think you all will speak up for me and share her stuff too. Like, that's not fair. That's at 2:11 in the call. And at 5:08 in the call, the defendant says, I probably could get her a ride to court like that. I know I can get unintelligible. Who she's speaking with, I believe it's the grandmother. Let me give her a ride. Let me get her a ride. I'll take Talisa out there. Let me give her a ride out there. The defendant, what you talking about? Is she really coming to the court? And the grandma said, we haven't talked about that. We haven't talked about that. And the defendant responded, no, you got to talk to her about that, Mom. I could go on and on.
Seems enough for me. Motion to revoke defendant's phone privileges is hereby granted. Defendant's phone privileges are your phone. You can always ask for a hearing on that. All right. Thank you. Court calls the case People versus Darius Grady.
Good morning, Your Honor. Amy Visor, appearing on behalf of the people.
Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of First Assistant Public Defender Jay Ballinger.
How's that going?
It's going well.
Is it?
I think so.
Is he treating you okay?
You know.
Okay, we'll talk later.
We'll talk later.
Permission to practice is granted.
Thank you, Your Honor. I'm here with and on behalf of Darius Grady. Can you please state your name for the record?
Darius Grady. Thank you, sir.
Your Honor, we are asking for a 3-week adjournment on this matter, awaiting a mitigation letter.
And no objection to that adjournment.
Probable cause conference will be adjourned to July 24th, 2020.
Was that July
22nd, 2025. You know, did you catch the other one?
Yeah.
All right. July 22nd, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Cortez Gray. Oh, boy.
Visor on behalf of the people.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Torcio Feaster.
Showing up in that North Carolina. He doesn't even understand why that makes my eyes go red. Permission to practice is granted. What are we doing?
Your Honor, we are requesting an adjournment in this matter. We were unable to get in contact with Mr. Gray, but now we have his correct phone number.
July 17, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court. What? Oh, I'll explain later. The whole North Carolina thing, like Tar Heels. Go to Tar Heels?
Okay, that's why. Court calls the case, People versus Marcus Harris.
And Alex Warren Green on behalf of Mr. Harris. Mr. Harris, can you state your name?
Mr. Simpson, Marcus Harris.
I'm doing
Minute
okay.
since I seen you guys.
What'd you say?
It's been a minute since I seen you, but how you doing?
I'm doing okay.
All right.
You're back.
Been a while, but yeah, I'm here for the month.
And you're like, so the last time you were here, were you allowed to wear shorts in my courtroom?
No.
No, right?
Should I put on to get here, put some on to get my butt up in? Because last time I was here, you took me to the back for coming late. That was a while ago, so I'm sorry about that. I will make adjustment on this the next time.
You believe it? You don't know?
Oh, be good.
All right, go ahead. I'm
Your
sure
Honor.
you will.
I'm asking the court to set this matter for a preliminary exam.
All discovery is complete.
So, Your Honor.
People have their witnesses available the 15th.
My best, Your Honor.
Preliminary examination in person will be set July 15th, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you, sir. You have a blessed one.
You take care of yourself. Court calls the case, People versus Alicia Henderson.
If you're ready for people.
Hannah Mackey on behalf of Ms. Henderson, who is to my right. Please state your name for the record. Alicia Henderson.
So that you know, because I criticized you. I felt safe that way. You got me. You got me. It's just, thank you. All right, go ahead.
Your Honor, we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
All right.
Before we do so, Your Honor, I was not here at the last hearing, but I do know that we adjourned to explore restorative justice resolutions in this case. The notes that I have from the previous APA that covered indicated that both parties were in fact agreeable to the restorative justice resolution, which would have them at the dispute resolution center, resulting in the ultimate dismissal of this matter if that is successful. However, there was a bench warrant issued, I think, because she failed to appear at the last hearing, as well as the required paperwork not having been submitted yet by counsel. So I do want to confirm on the record before we set this for exam that the parties on defense side, or defense rather, is rejecting the restorative justice resolution before we proceed to exam.
That is correct, Your Honor.
Which part?
All
of it? You're rejecting it?
We are.
We can go ahead and do what we were gonna do just about 20 minutes ago.
The bench warrant was recalled. Because
Yes, it was.
able to.
That's why she walked in.
Yes, sir.
And now, what do you want me to do?
Set for exam, please.
Please? Oh, so why was Janaza like whispering?
She just wanted to talk to me.
So it wasn't anything about the case? No, okay. All right.
We'll go ahead, we'll set it.
No, go ahead. What were you gonna say? I got all the time in the world.
Because the restorative justice resolution required contact, we normally request that those conditions are changed for consensual contact so that resolution can occur. I'm not certain if that happened at the last hearing or not, so we'll do it right this moment. But before we are done with the case, I did want to confirm that standard no contact conditions are in effect.
My client hasn't been in contact with the complaining witness regardless, so.
I don't think we changed anything. No, I haven't. I don't know why I'm checking. Okay. So would the people have their witnesses available?
What was that date, Your Honor? I'm sorry.
15.
We will try our best.
Preliminary examination in person, 5/15/2025, 9 a.m. before Judge Washington. Bond will continue. I don't see that any conditions were changed.
Okay.
So, whatever the original conditions are still in. Court does call the case People versus Elton Bell.
Zachary Ward on behalf of the people.
Cameron Dodge on behalf of Mr. Bell. Your Honor.
Wow, it's been like 2 hours now since I go ahead. I'll let you go.
He's answering my phone calls. He said his ride is just not answering his phone. I would like to ask for an adjournment. He literally was going to come here, make a payment for his.
You want me to send the car for him?
I
No?
can help him with that next time. He doesn't have transportation. He's relying on people who used to work for him in the past to get here. I'm even inclined to have him learn Zoom so he's able to attend, so we don't have to worry about this in the future. I don't believe he's ever not appeared before, based on my notes.
You don't know.
So we are going to be asking for an adjournment, Your Honor.
Response from the people.
Your Honor, this is a larceny case where the defendant took a check from the victim for $2,000 and for I think over a year to run around to do the work, I'll pay you back sort of thing. And here he is supposed to show up and pay some money for a misdemeanor offer and he doesn't have a ride. We haven't seen photographic proof of him not having a ride. So
I don't know what that photographic proof of somebody not having a ride would be.
Well,
Me sitting in my house?
He suggested it.
I don't know. It's a running joke.
Yes, that was.
And Your Honor, he is 65. He receives quite little Social Security. He doesn't work. He has injuries. We're trying to provide. He was going to come with documentation of his injuries.
Are you on the docket next week?
I should be.
Okay. So what
He will
I'll
show
do is
up.
I'll adjourn it out a week. If he doesn't show up, then I take you into custody.
I'm okay with that.
You're okay?
Yeah. Thank you, Your Honor.
Good.
She is good with that.
Sounds like she is?
Yes.
Oh, yeah. He's just like, yeah, she'll be.
Now she's gonna, even if we're off, I'll be here.
Probable cause conference, July 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Mr. Dish didn't seem to care, did he? Court calls case of the People versus Thomas Vash.
Word on behalf of the people.
Morning again, Your Honor. Constable Bill Basie on behalf of Mr. Thomas Vasher, who's approaching the podium to my right. Mr. Vasher, can you state your full name for the record, please?
Thomas Vasher. All right, what are we doing?
Are you sure? Yeah.
Really?
Sorry. Your Honor, today's the date and time set for probable cause conference. At this time, my client has been offered by the APA, and he wishes to avail himself of that offer, Your Honor.
Your Honor, the plea offer extended by the people was that Mr. Basher was made to charge count 2, the people who dismissed count 1.
That's correct reflection, Your Honor.
Did you fill out a plea form? Even though it's the stated count, I've got to have the plea form.
Okay, I was under the impression that the plea form didn't need to be filled because it was already on there, but we can fill it out, Your Honor.
That, although it's a stated count, because the change, but the defendant has to acknowledge you need to fill out a plea form. I don't care whether it's stated.
Understood.
I'll pass it.
Thank you.
Court recalls case People versus Thomas Vasher.
Dr. Moore, on behalf of the people.
Crossing go base on behalf of Mr. Thomas Vasher, who is present to my right, Your Honor. Mr. Vasher, can you state your name for the record one more time?
Thomas Vasher.
Standing is that the defendant will be pleading guilty to count 2, the receipt and concealment of stolen property less than 200, which is a misdemeanor punishable by up to 93 days in jail. Upon a successful plea to that charge, count 1 would be dismissed.
That is the correct reflection, Your Honor.
May I have it sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Raise your hand.
Thomas Vasher.
Sorry.
We had him sworn. Sir, it is this court's understanding that you are going to be pleading guilty or no contest to the charge. Is that this report? No contest to the charge of receipt and concealment of stolen property less than $200.
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand that while in taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about it. I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge.
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights? Look at paragraph 5. You say those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not that I know.
No.
Not that I know.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No,
Has anybody threatened you or coerced you in any way?
no, Your Honor.
You're doing this voluntarily
Yes.
of your own free will.
Yes, Your Honor.
All right. Court has been handed and has been provided and has reviewed Washington County Sheriff's Office report for their case number 255214. Any objection to the court having reviewed that report?
No, no objections, Your Honor.
Sir, I do have to advise you that any sentence evaluation and or agreement regarding your case, if you were to commit misconduct from the time I accept your plea to the time of your sentencing, that the court would not be bound by that. You understand that?
Yes, Your Honor.
You understand also that if you commit that misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that, sir? All right. Counsel, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Is counsel aware of any other promises, threats, or inducements which caused this plea?
None, Your Honor.
Has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied as well, Your Honor.
Court will accept the defendant's plea of no contest to this charge. The count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be July 31st, 2025, 10 a.m. That is before Judge Washington.
Here, may I address bond when appropriate?
Figured you want to. Go ahead.
Your Honor, now that my client has dealt with this case, the only other case that we'd be holding him is a driving without a license case out of.
What?
Now that my client has dealt with this plea and the felony was dismissed, my client is asking to be released on a PR bond. The only other case that he has currently is a license case out of 14B.
And I would already given that would be reduced to the PR bond. If I
Yes.
was reinstated.
Response?
Your Honor, given that the felony is now gone, I don't necessarily object to the court reconsidering bond. However, I would you have 3 pending board requests, one for fleeing third OUNID in March, a RNO in April of this year, and a enforcement in the building from May of this year. At the time of this offense, the defendant was in abscond status from circuit court probation.
Your Honor, my client asked that he once again be given a PR bond. If the court deems it appropriate, he can go on a tether. He has no issue doing that. He just wants to get out, hopefully get back to his job. His girlfriend was here for support, but she
Mr.
had.
Basher, it really is not helping your cause to sit there and try to mouth anything to me. All right? Because I'm trying to listen to your attorney and not pay attention to you.
Yes, Your Honor.
He does have some support here. She was here in the court waiting for him for about 3 hours, but she had to leave. As I said, Your Honor, the only other matter that would be holding him is a driving case. And these
Go ahead.
these other charges that are pending have been pending for a long time. We haven't got anything. So
Are those going to be coming forth anytime soon or what? I mean,
The APAs who are assigned to those wards aware, and it looked very chargeable to me, Your Honor.
also, Your Honor, my client has been in custody for 45 days now.
Yes. I'm missing out on I got a whole bunch of promotions through school. Say university. Like, that's my biggest thing.
all right, I will grant the defendant's motion to modify his bond. I'll set his bond at a $10,000 personal recognizance bond. Defendant may be released on a GPS tracking tether prior, or can be released only with the GPS tracking tether in place, location tracking.
Understood, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Anna Mackey on behalf of Mr. Hassani, who is to my right. Please state your name for the record.
My name is Ardeshir Hassani. And my apologies for wearing shorts, Your Honor. I was
And
not aware.
sandals.
And
I've-
flip-flops.
Did you just come from the beach or something?
Mr. Brown told him it's summertime and hot in the streets. That's what Mr. Lauren Brown said.
Laura Brown said that
Sure did.
and said that this was appropriate?
Look at him smiling back there.
Yeah, I know. I see him out there. Go take Mr. Brown's pants and come back. You know? All right. I know Mr. Brown didn't tell us to show up there, but I don't know what man he's trying to say. What are you looking to do?
The green sheet, Your Honor, adjournment. We're waiting discovery.
Fine.
Thank you.
It is a green sheet. Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond continued.
Thank you, and I'll make sure Mr. Hassani is in pants and shoes.
Sure. Thank you.
Will do.
Court calls the case People versus Dale Miller.
Virtual disappearance. Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now. Mr. Miller, will you state your name for the record?
Dale Joseph Miller, the Alpha and Omega. Will you give this in, please?
Probably not, but I'll look at it first.
Okay.
Thanks. Judge, Mr. Miller was found incompetent but restorable.
Yes.
The opinion that I have has this case also listed on it. I'm not sure. I think maybe
What's your date of your report?
I want to say it was like May 6th.
I have a May 8th.
Okay,
report.
May 8th.
I'm opining that he's incompetent to stand trial, but likely to obtain competence was the proper course of treatment.
Correct. So I don't know if this one just got behind the other three, but I have an order prepared.
All right.
The court to sign. He's awaiting treatment at the forensic center. And just for the court's information, next review date on those other three matters are the 14th of August.
Am I allowed to speak real quick?
No, I wouldn't recommend that.
I just want to let you know I'm the original son of God, the Alpha and Omega, mighty God, the only child conceived from Yahweh, Angelica, and the Holy Spirit. The devil is inside Barack Obama, Azazel. He was at Area 51. Semyaza, his sidekick, is inside Pope Francis. The book of Revelation is about me, and I have 12 sisters that are down here too. Christ comes from me in heaven too. I sent him into this world. I created the heaven and the angels. Azazel kissed my wife Danielle twice in heaven. That's why he was put down here. He caused the fall, sending a male into the Garden of Eden to sleep with Eve. So he's paying the price now, and he is going to be dealt with soon. I'm going back to heaven soon. The rapture is going to happen soon, and I will come back after 7 years. I'm the Alpha and Omega, the Lion of Judah. Christ is the Lamb of God. I put everything in that note she's supposed to give you, but you guys won't let me speak. Lauren, the girl this case is over, is one of my 12 sister wives.
Okay.
About the case.
And
all right, I'm
letting you know you guys haven't given me a chance to defend myself. I try to let you know.
I let you talk, but now I'm done.
Okay. Been warned. You will be dealt with. I'm the real judge of this world.
Okay.
You're going.
I'll await that.
Thank you.
September 4th for 2025, 9 a.m. Round continued. You know, I've heard that same thing from Feaster. Every conversation I have with him. Every conversation with Feaster starts that way. I don't really think it's up to you.
Hello, can I have your name, please?
My name is Daniel Magoo.
Okay, just a moment. Okay, you said your last name is pronounced Magoo?
Yes, ma'am.
And generally speaking, I appoint the public defender's office to represent at least at the arraignment stage, but I was informed that you didn't want to speak with the public defender, so are you intending to represent yourself for the arraignment?
I'm here to figure out what the charges are. What am I being charged with?
Now calling case number 25S00289. This is the State of Michigan versus Daniel Ryan Magoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So, as
Who's the complaining victim?
as part of the proceedings, can I have you please state your name for the record?
My name is Daniel Magoo,
Okay.
and I am not a surety of the state. I'm not a ward of the state. Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So what we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025 at 6988 McKean, Lot 72. You did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of Alyssa McCloskey, an individual with whom you have a child in common, by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use
Let
of a
me
telephone
rephrase.
service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone. I suppose it could also be a computer or something else
No, that
you
didn't
could
happen.
use. Okay. And again,
February,
as I
what were the
stated,
dates? What dates?
between February 15th and June 23rd
Of this
of
year?
this year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you're being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Okay. So the way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not, like I said before, I'm not a surety. I'm not a ward. I'm actually a protected individual and I have did no crime. There has been no body of a crime, no corpus delicti. I have committed no crime at all.
Mr. Magoo, if I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So
if there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delicti. It can't happen. And if you do try to enter in a plea of competency or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
okay, so Mr. Magoo, we will not be proceeding today with the arraignment. You are free to go to the door and tell the jail that you are finished. Thank you.